Welcome to the audio reading of Charged with a Sex Crime: Common Defense Strategies in Sex Crime Cases. If you're facing a sex crime charge in Missouri, Illinois, or a federal sex crime charge, the stakes could not be higher. Your reputation, freedom, and future may all be on the line. This free ebook is designed to help you understand the legal process, your rights, and the defense strategies available to you. Chapter 0. Introduction. Few crimes, if any, carry the stigma and social repercussions as sex crimes. If convicted, someone could serve decades behind bars, face lifetime registration as a sex offender, and face severe restrictions on where they could live, work, and travel. But being accused, or even formally charged, is a far cry from a conviction. People do beat these cases. With Combs' Waterkotte by your side, you can too. This ebook explains how. What this book covers. Sex crime defense in Missouri is not based on emotion, public opinion, or headlines. It is based on statutes, evidence, procedure, and strategy. Each chapter walks through a critical part of that process. Chapter 1. Common Sex Crime Charges in Missouri. An overview of Missouri's sex crime statutes and what the prosecution must legally prove in order to convict. Chapter 2. What happens after a sex crime accusation or arrest in Missouri. A breakdown of how investigations unfold, how charges are filed, and what typically happens in the early stages of a case. Chapter 3. Mistakes that can destroy a sex crime defense case. The early decisions and actions that can strengthen, or seriously undermine, a defense. Chapter 4. How defense attorneys evaluate sex crime cases. How experienced Missouri defense lawyers analyze statutes, evidence, and weaknesses in the prosecution's case. Chapter 5. Consent. When consent is a valid defense under Missouri law, when it is legally irrelevant, and how these distinctions shape strategy. Chapter 6. False or unreliable allegations. How credibility, inconsistencies, motive, and memory issues are evaluated and tested. Chapter 7. DNA and forensic evidence. The limits of forensic evidence, including touch DNA, transfer issues, mixed samples, and expert testimony. Chapter 8. Digital evidence. How text messages, social media, device extractions, and cloud data are analyzed, challenged, and contextualized. Chapter 9. Constitutional and procedural defenses. Search warrants, suppression motions, statements, and the legal safeguards that limit how evidence can be obtained and used. Chapter 10. What sex crime defense looks like in action. How defense strategies affect dismissals, reductions, plea negotiations, and trial outcomes. Chapter 11. Real-life examples of expert sex crime defense in Missouri. Real case results demonstrating how strategic defense work has protected clients facing serious allegations. Sex crime accusations are serious. The consequences are life-altering. But Missouri law requires proof, not assumptions. Understanding how sex crime cases are defended is the first step toward protecting your rights and your future. Chapter 1. Common sex crime charges in Missouri. All sex crime cases are different, and the best defense will depend on the specifics of your case. Missouri law defines multiple categories of sex offenses, each with different legal elements, evidentiary issues, and defense strategies. The type of allegation you're facing will determine the first steps toward challenging the evidence and defending yourself. Why the type of sex charge matters. Missouri sex crimes are defined by statute, largely in Missouri Revised Statutes, Chapter 566. Each statute has specific elements the state must prove beyond a reasonable doubt. Those elements, such as force, lack of consent, age, intent, or specific conduct, determine what evidence matters and what defenses may apply. In some cases, consent is central. In others, consent is legally irrelevant. In some cases, the entire case turns on credibility. In others, it turns on forensic, digital, or procedural evidence. That's why experienced Missouri sex crime defense attorneys do not treat all sex crime accusations the same, even if the media and prosecution do. Types of sex crimes in Missouri. Sex crime allegations in Missouri cover a wide range of conduct, and the label on the charge matters less than the elements the state has to prove and the evidence prosecutors rely on. Common charges include sexual assault and rape. Sexual assault and rape allegations involve claims of non-consensual sexual intercourse or penetration. In Missouri, these cases are usually prosecuted as rape in the first or second degree under RSMO, Section 566.030 and Section 566.031, depending on the facts alleged. These cases are often emotionally charged and widely misunderstood. A charge does not mean the evidence is strong. Many cases ultimately rise or fall on whether the prosecution can actually prove each required element beyond a reasonable doubt. From a defense standpoint, these cases often hinge on credibility and consistency of the allegation over time, medical or forensic evidence and its limitations, digital evidence such as texts, messages, or location data, the broader context surrounding the alleged incident. Sexual abuse. Sexual abuse allegations generally involve claims of unwanted sexual contact and are commonly charged as sexual abuse in the first or second degree under RSMO Section 566.100 and Section 566.101. Although these charges may sound less severe than rape allegations, they can be just as complex to defend and also carry harsh penalties. These cases often come down to how the law defines sexual contact and whether the evidence supports the charge as filed. From a defense perspective, key issues often include whether the alleged conduct meets the statutory definition, inconsistencies in statements or timelines, lack of corroborating physical or digital evidence, whether evidence was lawfully obtained, sexual misconduct and indecent exposure. Missouri law also includes sexual misconduct offenses, which can overlap with what many people think of as indecent exposure or inappropriate sexual behavior. These charges are commonly brought under RSMO Section 566.093 and Section 566.095. These cases are frequently oversimplified and, in some situations, overcharged. Context and intent matter, and assumptions often play an outsized role in how these allegations are interpreted. From a defense standpoint, these cases often focus on whether intent can actually be proven, whether the alleged conduct fits the statute, witness credibility and reliability, context that may undermine the prosecution's narrative. Statutory rape, age-based offenses. Statutory rape allegations involve sexual intercourse with a minor below Missouri's legal age thresholds. These cases are typically charged as statutory rape in the first or second degree under RSMO Section 566.032 and Section 566.034. A key difference in age-based cases is that consent may not be a legal defense if the alleged victim is under a certain age, even where both parties believed the interaction was consensual. Defense strategies therefore focus on what the statute actually requires the state to prove. From a defense standpoint, these cases often hinge on whether the required age elements can be proven, whether the correct statute was charged, timeline, and identity issues. Digital evidence, such as messages or images. Statutory sodomy. Statutory sodomy allegations involve deviant sexual intercourse with a minor and are commonly charged as statutory sodomy in the first or second degree under RSMO, Section 566.062 and Section 566.064. Deviant sexual intercourse refers to sexual acts involving oral or anal contact with another person's genitals, or penetration of the anus or genitals by an object when done for sexual arousal or gratification. Like statutory rape cases, these allegations are highly element-driven, and prosecutors must still prove what the law requires. From a defense perspective, these cases often focus on whether the alleged conduct actually occurred as claimed, whether evidence supports the charged degree, opportunity and timeline issues, reliability and completeness of digital evidence. Child molestation. Child molestation allegations involve sexual contact with a child under specific age thresholds and are prosecuted as child molestation in the first, second, third, or fourth degree under RSMO, Section 566.067, Section 566.068, Section 566.069, Section 566.071. These cases often involve unique investigative techniques and heightened emotional pressure, making it especially important to separate allegations from proof. From a defense standpoint, these cases often hinge on reliability and consistency of statements, how interviews were conducted and documented, whether physical or digital evidence supports the allegation, whether investigative procedures were proper, possession of child pornography and related offenses. Allegations involving child pornography may include possession, creation, or distribution of explicit material involving minors and are commonly charged under RSMO, Section 573.037. These cases are typically evidence-heavy and often depend on digital forensics rather than eyewitness testimony. From a defense perspective, these cases often focus on attribution, who actually possessed or controlled the device, whether possession was knowing or intentional, chain of custody and forensic handling, legality of searches involving devices or cloud data, internet sex crimes and online enticement. Internet-based sex crime allegations often involve undercover investigations, online communications, or accusations of attempted sexual activity involving minors. A common charge in this category is enticement of a child under RSMO, Section 566.151. Another is promoting sexual performance by a child under RSMO, Section 573.023. These cases often depend on how online conversations are interpreted and whether identity and intent can be proven. From a defense standpoint, these cases often hinge on whether the accused can be linked to the account or device, completeness and context of online communications, intent versus fantasy or misinterpretation, legality of digital searches and data extraction. Prostitution. Prostitution charges involve offering or engaging in sexual acts for money or something of value, and are commonly charged under RSMO, Section 567.020. While these charges may not involve allegations of force or coercion, they can still carry serious legal and personal consequences. From a defense standpoint, these cases often focus on what was actually agreed to or communicated, whether evidence supports intent, law enforcement conduct during stings or arrests, credibility of undercover or third-party witnesses. Solicitation. Solicitation allegations involve attempts to arrange or pay for sexual services and are commonly charged under RSMO Section 567.030. These cases often come down to assumptions about intent rather than completed conduct. From a defense perspective, these cases often hinge on whether intent can be proven beyond speculation, context of communications, reliability of recordings or reports, constitutional issues related to enforcement tactics, sexual contact with a student and authority-based offenses. Missouri also prosecutes sex crimes involving certain positions of authority. One example is sexual contact with a student under RSMO, Section 566.086, as well as related offenses involving teachers, employees, or volunteers. These cases often carry professional consequences in addition to criminal exposure, and are charged aggressively because of the relationship element. From a defense standpoint, these cases often focus on whether the required relationship existed, whether the alleged conduct fits the statute, digital evidence and timelines, motive and credibility issues, human sex trafficking, sexual exploitation. Human sex trafficking allegations involve claims of exploiting or coercing individuals into sexual activity and are charged under statutes such as RSMO Section 566.206. These cases are fact-intensive and often involve complex investigations with multiple parties. From a defense standpoint, these cases often hinge on what conduct is actually attributable to the accused, whether coercion or force can be proven, credibility of cooperating witnesses, procedural and constitutional issues, why the type of sex crime matters. Each Missouri sex crime statute has specific elements the state must prove beyond a reasonable doubt. Defense strategies are shaped by those elements, the evidence presented, and how the investigation was conducted. In the chapters that follow, we'll break down how defense attorneys challenge evidence, expose weaknesses in the prosecution's case, and protect the rights of people facing these allegations. Understanding the category of charge involved is the foundation for understanding how a sex crime case can be defended. Chapter 2. What happens after a sex crime accusation or arrest in Missouri? Sex crime cases in Missouri often begin long before anyone is arrested and before the accused even knows an allegation has been made. Many people are caught off guard because they assume the process starts with handcuffs or a court date. In reality, Missouri sex crime investigations frequently unfold quietly, well before formal charges are filed. Understanding what typically happens after an accusation or an arrest can help reduce uncertainty and prevent early mistakes that can damage a defense. How sex crime investigations often begin. In Missouri, sex crime investigations commonly start in one of several ways: a report made by an alleged victim, a disclosure to a school, employer, or mandated reporter, a digital tip or online investigation, information uncovered during an unrelated investigation. Once a report is made, law enforcement often begins investigating before contacting the accused. That investigation may include collecting statements, reviewing messages or social media, obtaining medical records, or seeking digital evidence. In many cases, the first contact with the accused is framed as voluntary or just asking questions. Defendants need to approach this carefully and with a criminal defense lawyer because statements made early, often without full information, can shape the entire case. Contact by law enforcement and voluntary interviews. One of the most common points of confusion is when police reach out and ask to talk. Officers may say they just want to hear your side. It will clear things up. You're not being detained. This can change quickly in a single conversation. While an interview may technically be voluntary, anything said can be used later. In sex crime cases, investigators are often trying to lock in statements, identify inconsistencies, gather admissions, try to trip you up. Assess credibility. From a defense perspective, early statements are closely scrutinized, especially if made without understanding the evidence already in existence. Search warrants and evidence collection. Sex crime investigations frequently involve search warrants, particularly for cell phones, computers or tablets, cloud accounts, social media, or messaging platforms. In Missouri, investigators may seek warrants early in the process, sometimes before an arrest is made. Digital evidence often plays a central role, even in cases that appear to be based solely on allegations. How evidence is obtained is important. Warrants must be properly supported, limited in scope, and executed lawfully. If they are not, the evidence collected may be challenged later. Arrests and charges. An arrest may occur shortly after an investigation begins, after weeks or months of evidence gathering, or at the same time charges are formally filed. In some cases, individuals are arrested without advance warning. In others, they are informed through an arrest warrant and instructed to appear in court. Being arrested does not mean the case is complete or that the evidence is overwhelming. In Missouri, prosecutors can file charges based on probable cause, even when significant factual disputes remain. Bond, conditions of release, and no-contact orders. After an arrest, the court will typically address bond and conditions of release. In sex crime cases, these conditions are often strict and may include no contact with the alleged victim, no contact with certain witnesses, restrictions on travel, limitations on internet or device use, orders affecting residence or employment. No-contact orders are common and are taken seriously. Violating a condition of release can create new charges and significantly complicate a defense, even if you're eventually found not guilty on the original charges. The role of prosecutors early on. Once charges are filed, prosecutors begin shaping the case they intend to present. This includes deciding which charges to pursue, evaluating what evidence supports each charge, determining whether additional investigation is needed, anticipating your defense strategy and how to counter it. Sex crime cases are often charged conservatively at first, or aggressively, depending on the facts and the prosecutor's assessment of the evidence. Overcharging can occur, particularly early in a case, as prosecutors also consider office policy, public pressure, and perceived risk when deciding how to charge a case. Why early stages matter so much. What happens in the early stages of a sex crime case often affects everything that follows. Statements, evidence collection, bond conditions, and procedural decisions can shape how the case is charged, influence what evidence is admissible, affect negotiations later, limit or expand defense options. Many people assume their chance to defend themselves comes later, in court. In reality, sex crime cases are often shaped well before a trial date is ever set. What this means. Going forward. An accusation or arrest can feel overwhelming, especially when the process is unfamiliar and emotionally charged. In the chapters that follow, we'll explain how defense attorneys analyze evidence, challenge accusations, and protect the rights of people facing these charges. That analysis always begins with understanding how a case started and what has already happened. Chapter 3. Mistakes that can undermine a sex crime defense early. The last thing you want to do if accused of a sex crime in Missouri is make a horrible situation even worse. Sex crime cases don't operate on common sense. The instincts that help people navigate everyday conflicts often work against them in a criminal investigation. The mistakes discussed in this chapter are not about bad intentions or reckless behavior, but about how even the best intentions can work against you and make a favorable outcome more difficult to achieve. Believing a lawyer can wait until later. One of the most common misjudgments in sex crime cases is believing that hiring a lawyer can wait until charges are filed or a court date appears. Many people assume there is no reason to involve a defense attorney until something official happens. In reality, sex crime cases are often shaped long before that point. By the time charges are filed, investigators may already have collected statements, obtained digital evidence, and developed a working narrative that prosecutors will rely on moving forward. Decisions made during this early period, often without legal guidance, can quietly limit what defenses are available later. Waiting to involve a lawyer is rarely about denial or carelessness. It usually comes from not realizing how much of the case is already in motion. Without an understanding of what stage the investigation is in, people often make well-intentioned decisions about conversations, explanations, or timing without seeing how those choices will be interpreted down the line. Once a case reaches the charging stage, certain things cannot be undone. Statements are fixed. Evidence has been preserved. Assumptions have hardened. What felt like waiting to see what happens can end up narrowing options before a defense strategy even begins. In sex crime cases, early legal involvement isn't about escalation. It's about awareness. Understanding what is happening before the case takes a shape that's harder to challenge. Assuming early conversations are informal or harmless. One of the most common misjudgments is believing that early conversations with law enforcement are informal, exploratory, or simply a chance to clear things up. When contact feels casual, people often assume the stakes are low. In reality, early statements frequently become permanent reference points. Investigators may compare later evidence to what was said initially, looking for inconsistencies or omissions. Even statements made in good faith can later appear misleading when viewed alongside information the accused person did not know existed at the time. This is not about dishonesty. It's about the fact that early conversations often happen before the full scope of the allegation or evidence is understood. Trying to fix the situation independently. Another common mistake is attempting to manage the situation without understanding how much is already in motion. People try to explain context, justify actions, or clarify misunderstandings because they believe the problem is simply confusion. In sex crime cases, these attempts often backfire. Investigations are not paused while someone tries to sort things out. New explanations can create new questions. Partial information can raise red flags. Efforts to control perception can look like consciousness of guilt, even when they are motivated by panic or fear. What feels like damage control to the accused can look very different once the case is viewed through a legal lens. Underestimating bond conditions and no-contact orders. When release conditions are imposed, many people assume they are temporary or flexible, especially if they believe the accusation is false. That assumption can be costly. Courts enforce bond conditions and no-contact orders strictly, regardless of how the underlying case turns out. Violations, intentional or accidental, can shift attention away from the original allegation and create new legal problems that have nothing to do with whether the accusation can be proven. In sex crime cases, these conditions are part of how the system manages risk while a case is pending, and they are treated seriously from the outset. Talking too broadly about the accusation. People naturally want reassurance. They want to tell their story. They want someone to say, "This will be okay." As a result, accusations often get discussed with friends, family members, co-workers, or others who feel safe. The problem is that conversations rarely stay contained. Details are repeated imperfectly. Messages are forwarded. Screenshots are taken. Digital communication leaves trails that can surface later in unexpected ways. What begins as a private attempt to process the situation can quickly become part of the broader narrative surrounding the case. Believing the truth will automatically prevail. Perhaps the most damaging assumption is the belief that the truth will eventually sort everything out on its own. Many people assume that because they know what happened or didn't happen, the system will catch up once emotions cool and facts are reviewed. Sex crime cases don't work that way. Legal outcomes are driven by evidence, statutes, and how proof is presented, not by intention or fairness in the abstract. Waiting for things to resolve themselves can allow weak assumptions to harden into formal allegations and charges. This belief often delays engagement with the reality of the process at precisely the moment when understanding that process matters most. Why early mistakes matter later. Mistakes made early in a sex crime case don't usually feel dramatic in the moment. They feel reasonable. They feel human. But they can quietly limit options later, narrowing the range of defenses available and shaping how evidence is interpreted. Avoiding early misjudgments is not about playing games or outsmarting the system. It's about understanding that sex crime cases are built in stages, and each stage influences the next. The chapters that follow focus on how defense attorneys analyze accusations, challenge evidence, and expose weaknesses in the prosecution's case. That work is most effective when the early stages haven't already created unnecessary obstacles. Understanding what not to assume is often the first step toward understanding how a sex crime case can actually be defended. Chapter 4. How defense attorneys evaluate sex crime cases. When thinking about a sex crime case, you might imagine a single emotionally charged cross-examination or closing argument that will decide everything. In reality, experienced Missouri criminal defense attorneys do not begin with arguments. They begin by evaluating the evidence. Sex crime cases are not decided by emotion, public opinion, or how an allegation sounds at first glance. They are decided by Missouri state law, evidence, and whether the prosecution can actually prove every required element beyond a reasonable doubt. Different sex crime cases require different defense strategies, and no single defense applies to every accusation. Defense evaluation starts with the law, not the allegation. Every sex crime charge in Missouri is defined by statute. Each statute contains specific elements the prosecution must prove. If even one element cannot be proven, the charge cannot stand. Defense attorneys begin by identifying the exact statute charged, the degree of the offense, what the state is legally required to prove, what evidence is actually relevant to those elements. This step matters because not all allegations trigger the same legal questions. In some cases, consent is central. In others, consent is legally irrelevant. In some cases, age alone determines exposure. In others, intent or force becomes the focus. The evaluation always starts with the law. Evidence matters more than emotion. Sex crime allegations often carry strong emotional reactions. Defense strategy does not. Experienced defense attorneys focus on evidence, not outrage or assumptions. This includes statements and how they evolved over time, physical or forensic evidence and its limitations, digital evidence such as texts, images, or location data, witness credibility and consistency, how evidence was collected and preserved. An accusation alone is not proof. A charge alone is not proof. The question is always whether the available evidence actually supports the charge as filed. Credibility is often central, but not always. Many sex crime cases turn on credibility. Defense attorneys assess whether statements are consistent internally, whether accounts change across interviews, whether outside evidence corroborates or contradicts claims, whether timelines make sense, whether motives or external pressures exist. At the same time, experienced attorneys understand that credibility alone does not decide every case. Some cases rise or fall on forensic interpretation, digital data, identity or attribution issues, procedural or constitutional violations. Evaluation means identifying what truly matters in this case, not assuming all cases work the same way. How investigations shape defense options. Defense evaluation also considers how a case was investigated. This includes whether statements were obtained lawfully, whether search warrants were valid and properly executed, whether digital evidence searches exceeded their scope, whether interviews followed proper procedures, whether evidence handling raises reliability concerns. Procedural laws exist to protect constitutional rights and ensure fairness. When investigations cut corners, defense options expand. When procedures are followed carefully, strategies may shift. No single defense applies to every case. Most sex crime cases involve overlapping issues. A case may involve questions about consent, challenges to credibility, disputed digital evidence, forensic interpretation issues, constitutional concerns. Defense attorneys evaluate how these factors interact, not which label fits best. Strategy is shaped by the entire picture, not one isolated argument. Strategy evolves as evidence develops. Defense evaluation is not static. As cases move forward, new evidence may surface. Prior assumptions may change. Weaknesses may become clearer. Negotiation or trial risk may shift. Strong defense representation requires continuous reassessment. What matters early may not matter later. What seems minor at first may become central. What this means for the chapters that follow. The chapters that follow examine common defense approaches in sex crime cases, including consent-based defenses, false or fabricated allegations, DNA and forensic evidence, digital evidence, constitutional and procedural issues. These are not checklists or guarantees. They are examples of how experienced defense attorneys analyze, test, and challenge the prosecution's case based on the facts, the law, and the evidence involved. Chapter 5. Consent as a defense in Missouri sex crime cases. Consent is one of the most commonly discussed and most misunderstood issues in Missouri sex crime cases. Many people assume that if sexual activity was consensual, the case should end there. Missouri law does not work that way. Whether consent matters depends entirely on the statute involved and the elements the prosecution must prove. For sex crimes, defense attorneys, consent is not a starting assumption. It is a legal issue that must be evaluated carefully within the boundaries of Missouri law and the evidence actually available. Why consent is often misunderstood. Outside the courtroom, consent is often discussed in general or moral terms. Inside a criminal case, Consent is a legal concept defined by statute. Some Missouri sex crime charges require the prosecution to prove lack of consent as a specific element. Others remove consent from the analysis entirely, regardless of what the parties believed or intended. When consent is legally relevant under Missouri law, consent becomes a potential defense only when the charged offense includes lack of consent or forcible compulsion as an element. Examples include rape in the first degree, RSMO, Section 566.030. These cases involve allegations that sexual intercourse occurred through force, threat, or when the other person was incapable of consenting, drugged, drunk, or mentally unable to agree. Importantly, the defense does not have to prove that the sexual act was consensual. The burden is on the state to prove it was not consensual. Rape in the second degree, RSMO, Section 566.031. These cases involve allegations of sexual intercourse without consent, even if forcible compulsion is not alleged. For example, someone who is unconscious, or a boss who threatens to fire an employee if they don't have sexual intercourse. Sexual abuse in the first degree, RSMO, Section 566.100. Similar to first-degree rape, but involves sexual contact, like touching their private parts, instead of intercourse. Sexual abuse in the second degree, RSMO, Section 566.101. Similar to second-degree rape in the same regard. In these cases, lack of consent is not presumed. It must be proven beyond a reasonable doubt, and it is not the defendant's burden to prove the accuser did consent. From a defense standpoint, this means the prosecution's evidence must be examined closely to determine whether it actually establishes the absence of consent under the law, not merely whether an allegation has been made. When consent is not a legal defense. In many Missouri sex crime cases, consent is legally irrelevant, even if both parties believed the interaction was consensual. This includes age-based and authority-based offenses, such as statutory rape in the first degree, RSMO, Section 566.032. Statutory rape in the second degree, ARSMO, Section 566.034. Statutory sodomy in the first degree, HRSMO, Section 566.062. Statutory sodomy in the second degree, RSMO, Section 566.064. Child molestation, RSMO, Sections 566.067 to 566.071. Sexual contact with a student, RSMO, Section 566.086. In these cases, the law focuses on age thresholds or defined relationships. Consent does not negate the charge. A child 13 years old or younger is considered too young to make a decision regarding consent. In cases involving someone with a position of authority, like a teacher or police officer, consent is not considered a valid defense because of the power imbalance. Defense strategies in these cases therefore center on other issues, such as whether the required age elements can be proven, whether the correct statute was charged, identity or attribution issues, timelines and opportunity, digital or forensic evidence, constitutional or procedural violations, mistake of age and consent. As stated, Missouri law does not allow consent as a defense when a child is under the age of 14. However, under RSMO Section 566.020, mistake of age may be used as a defense in involving a person who is 15 or 16 years old, depending on the specific offense charged. How prosecutors attempt to prove lack of consent. When lack of consent is an element, prosecutors typically rely on a combination of evidence rather than a single factor. This may include statements made by the alleged victim, the timing and manner of disclosures, medical or forensic examinations, bruises or other injuries, witness testimony, digital communications before or after the alleged incident, behavior interpreted as consistent with non-consensual activity. No single piece of evidence automatically proves lack of consent. The prosecution must present a narrative that persuades a jury that consent was absent under the statute charged. From a defense perspective, this means examining not only what evidence exists, but how it fits, or fails to fit, the legal requirements of the offense. How defense attorneys evaluate consent-based cases. Criminal defense attorneys approach consent-based cases analytically, not emotionally. Key evaluation factors often include whether accounts remain consistent over time, whether details change across interviews or statements, whether outside evidence corroborates or contradicts the allegation, whether timelines are internally consistent, whether communications provide context that affects interpretation, whether assumptions are filling gaps where proof is lacking. Importantly, evaluation does not assume dishonesty. Inconsistencies can arise for many reasons. The question is whether the prosecution can still meet its burden of proof despite those issues. Credibility and context in consent cases. Many consent-based cases turn on credibility. Some do not. Defense attorneys assess credibility by looking at internal consistency of statements, consistency across time and setting, alignment with objective evidence, whether details evolve as new information emerges, whether outside pressures or incentives may exist. Common misconceptions about consent as a defense. Several misconceptions frequently arise in Missouri sex crime cases. Consent automatically resolves the case. Consent matters only when the statute makes it relevant. A prior relationship implies consent. Missouri law does not presume consent based on prior interactions. Lack of physical injury proves consent. Physical injury is not required to establish lack of consent. Consent only matters if force is alleged. Lack of consent can be an element even without forcible compulsion. These misunderstandings often lead people to underestimate exposure or overestimate the strength of a particular argument. How consent fits into a broader defense strategy. In practice, consent is rarely the only issue in a case. Consent analysis often overlaps with credibility challenges, digital evidence interpretation, forensic review, constitutional and procedural issues. Missouri criminal defense attorneys evaluate how these factors interact and which issues actually carry weight under the charged statute. Chapter 6. False or unreliable allegations in Missouri sex crime cases. Many Missouri sex crime cases move forward with little or no physical evidence. Instead, they rely primarily on allegations, making the accuser's testimony and that of other potential witnesses the central points of the case. In these cases, the central legal question is not how serious the accusation sounds, but whether it can be proven beyond a reasonable doubt using reliable evidence. Missouri law does not treat allegations as facts. They must be supported, tested, and corroborated through admissible proof. Missouri criminal defense attorneys focus on whether the prosecution's case holds up under close examination of the evidence. Why someone may falsely accuse you of a sex crime. Not every sex crime allegation is supported by reliable evidence. In some cases, accusations arise from factors unrelated to whether a crime actually occurred. Defense attorneys evaluate these cases by examining why an allegation was made, when it was made, and what external pressures or incentives may have been present. This analysis focuses on reliability, not assumptions. Below are common situations that defense attorneys see in cases involving false or unreliable accusations. Personal conflict, anger, or retaliation. Sex crime allegations sometimes arise after personal relationships deteriorate. This may include breakups or rejected advances, arguments or interpersonal conflicts, feelings of anger, jealousy, or resentment, perceived slights or humiliation. Missouri criminal defense attorneys examine whether the timing of the allegation coincides with a dispute or emotional fallout that could affect reliability. Custody, divorce, or strategic leverage. In family law and domestic disputes, allegations can be used to gain leverage. Common examples include custody or visitation battles, divorce or separation proceedings, attempts to restrict access to children, efforts to influence court decisions or negotiations, supporting evidence in an order of protection case. Because sex crime accusations can dramatically alter custody outcomes and personal freedom, defense attorneys pay close attention to whether an allegation emerged in connection with an ongoing legal dispute. Avoiding consequences or explaining other behavior. Some allegations arise to avoid personal consequences or difficult explanations. This may involve concealing consensual sexual activity from parents or partners, avoiding punishment for breaking rules or curfews, deflecting blame for substance use or risky behavior, dealing with shame after a sexual encounter they regret. In these cases, an accusation may develop as an explanation rather than as a report of an actual crime. Misunderstanding, memory gaps, or intoxication. Not all unreliable allegations are deliberate. Alcohol or drug use can affect memory formation, perception of events, interpretation of consent or boundaries. In some cases, individuals genuinely struggle to recall events clearly or later reinterpret what occurred based on incomplete or distorted memories. Defense attorneys examine whether intoxication, memory gaps, or confusion played a role in how the allegation developed. External pressure or influence. Some allegations do not originate from the person making them alone. Instead, they develop through conversations with others after an event has already occurred. This is most common in cases involving children, teenagers, or situations where an authority figure becomes involved early. This may include a child repeatedly questioned by a parent who believes something inappropriate must have happened, a student encouraged by a school administrator to think carefully about whether an encounter was appropriate, a counselor, teacher, or mandatory reporter asking leading or suggestive questions, family members or partners urging someone to describe an event in a particular way. Authority figures framing an experience using legal or disciplinary language the person did not originally use. Defense attorneys look closely at how an allegation was first disclosed, who was involved in shaping it, and whether suggestive or leading conversations occurred. Attention, sympathy, or validation. In some situations, an allegation may provide emotional reinforcement. This can involve seeking attention or care, receiving sympathy or validation, gaining support in a social or institutional setting. Defense attorneys consider whether external reinforcement may have influenced how an allegation was presented or maintained. Psychological, emotional, or trauma-related factors. Mental health and past trauma can affect how people perceive, remember, and later describe events. This may include difficulty recalling events clearly or in sequence, memory gaps or altered recall during periods of stress or emotional distress, interpreting later experiences through the lens of past trauma, blending emotional reactions with factual memory. Defense attorneys evaluate whether emotional or trauma-related factors may have influenced how an event was perceived, remembered, or reported, and whether that affects the reliability or consistency of the allegation. Motive alone is not the issue. Motive does not determine whether an allegation is true or false. Evidence does. Defense attorneys do not argue that an allegation is unreliable simply because a possible motive could exist. Instead, motive is examined alongside consistency of statements, corroborating or contradictory evidence, timelines, digital or forensic records, investigative procedures. When an allegation cannot be reliably supported by evidence, motive and context help explain why the accusation arose, not whether it should be believed automatically. How false allegations fit into a defense strategy. Understanding why an allegation may be unreliable helps defense attorneys identify weaknesses in the prosecution's case, test credibility against objective evidence, expose assumptions that replaced proof, demonstrate reasonable doubt where required. The focus is not on attacking individuals. It is on determining whether the prosecution can meet its burden of proof under Missouri law. How defense attorneys test reliability and credibility in Missouri sex crime cases. Defense attorneys do not evaluate allegations based on belief. They evaluate whether the allegation can be proven using reliable evidence. Key questions include: does the account remain consistent over time? Do details change between interviews, reports, or testimony? Are new details introduced after new information surfaces? Does outside evidence support or contradict the allegation? Do timelines align with known facts? Are assumptions filling gaps where proof is missing? Inconsistencies do not automatically mean an allegation is false. However, when the prosecution's case depends heavily on testimony, inconsistencies matter. The role of digital evidence in allegation-based cases. Digital evidence plays an increasingly central role in sex crime cases, especially when allegations involve private interactions. Defense attorneys closely examine text messages, emails, and direct messages, the full context of conversations, not isolated excerpts, missing or deleted communications, timestamps and metadata, account ownership and device access, whether messages were altered, cropped, or selectively presented. Digital evidence can either clarify credibility issues or create new ones. Messages taken out of sequence or without context can easily be misinterpreted. In some cases, digital evidence undermines assumptions made early in the investigation. In others, it confirms or complicates testimony. Either way, it often becomes central to evaluating reliability. Common misunderstandings about allegation-based cases. Several assumptions frequently arise in cases built primarily on allegations. If there's no physical evidence, the case will be dismissed. Missouri law does not require physical evidence in every case. Testimony is still considered evidence. Any inconsistency ends the case. Only inconsistencies that affect required elements matter legally. Recantations automatically stop prosecution. Prosecutors can continue cases even if statements change. Motive alone proves an allegation is false. Motive is one factor among many and does not replace proof. Chapter 7. DNA and forensic evidence in Missouri sex crime cases. DNA and forensic evidence often carry enormous weight in sex crime cases. Many people assume that if DNA connects the defendant to the alleged victim, the case is already decided. That assumption is wrong. Forensic evidence can be powerful, but it is also limited, contextual, and heavily dependent on how it is collected, handled, and interpreted. DNA cannot tell how, if, or when something happened. It does not establish consent, timing, or circumstances. It must be evaluated carefully against the legal elements the prosecution is required to prove. Why DNA evidence is often overestimated. DNA evidence is often critical in a case. Over 600 innocent people have been exonerated based on new DNA evidence since 1989. Hundreds more cases have been solved using DNA evidence. However, television and media use that to portray DNA results as proof beyond a reasonable doubt, when that is far from true. In reality, DNA evidence usually answers just one basic question: whether biological material linked to a specific person was found. Everything beyond that, how the DNA got there when it was deposited and what it means legally, requires interpretation. Those interpretations are often where the prosecution's case becomes vulnerable. Defense attorneys focus on separating scientific findings from assumptions layered on top of them. What DNA evidence can and cannot prove. DNA evidence can indicate the presence of genetic material. It cannot, by itself, establish whether sexual activity was consensual, whether a crime occurred, when contact took place, how DNA was transferred, whether the accused committed a criminal act. In many sex crime cases, the presence of DNA is not disputed. But the presence of DNA does not replace the prosecution's burden to prove every element of the charged offense beyond a reasonable doubt. Even in a case where someone's DNA was found in semen, it does not prove that the encounter wasn't consensual or that the claims aren't exaggerated. Common sources of DNA in sex crime investigations. DNA may be collected from a wide range of sources, including bodily fluids, skin cells, touch DNA, clothing or bedding, personal items, shared surfaces or environments. Not all DNA carries the same significance. Small amounts of genetic material can be transferred through everyday contact, shared spaces, or indirect handling. The presence of DNA alone does not establish criminal conduct. Touch DNA and secondary transfer. One of the most misunderstood aspects of forensic evidence is touch DNA. Touch DNA involves skin cells left behind through contact. These cells can be transferred easily and unintentionally. DNA may be transferred through brief physical contact, by handling objects another person later touches, through shared clothing, furniture, or bedding, indirectly through contact with other people or objects. In some cases, DNA may be present without the person ever being at the alleged location during the alleged event. Even when a defendant's DNA is found in someone's genital area, that does not automatically mean direct sexual contact occurred. Skin cells may have been transferred after someone touches an object or surface that previously had the defendant's DNA on it and later touches their own body. Because touch DNA is so easily transferred, defense attorneys examine whether investigators followed proper evidence collection procedures and considered alternative transfer explanations before drawing conclusions. Missouri law requires physical and biological evidence to be collected lawfully. Under Chapter 542 of the Missouri Revised Statutes, law enforcement generally must obtain a valid search warrant, based on probable cause and approved by a judge, before seizing physical or biological evidence, and officers must follow the limits of that warrant when collecting evidence. Mixed samples and partial profiles. Many forensic samples are not clean or complete. Sex crime cases often involve mixed DNA from multiple contributors, partial profiles due to low sample amounts, degraded samples collected long after the alleged incident. Interpreting mixed or partial samples requires judgment. Analysts must decide which genetic markers are significant and how to report probability or exclusion. Different analysts may view the same data differently, especially in low-level or complex samples. In these cases, the prosecution often relies on expert testimony to interpret the forensic evidence, while the defense uses its own experts to examine whether that evidence actually supports the charge beyond a reasonable doubt. Missouri law governs expert testimony through Chapter 490 of the Missouri Revised Statutes, which requires that experts be properly qualified, base their opinions on accepted methods, apply those methods correctly to the evidence in the case, and limit their conclusions to what the evidence actually supports. Timing gaps and collection delays. DNA evidence rarely comes with a timestamp. Criminal defense attorneys evaluate how much time passed between the alleged incident and collection, whether the location or items were exposed to other people or environments, whether normal activity could have introduced or removed DNA, whether degradation may have affected results. Delays in collection increase the likelihood of contamination, transfer, or loss of context. Timing matters because it affects how confidently DNA can be linked to a specific event. When evidence is collected long after an alleged incident, defense attorneys examine whether that collection complied with legal requirements in Chapter 542 of the Missouri Revised Statutes and whether the delay undermines reliability. Collection, handling, and chain of custody. Forensic evidence is only as reliable as the process used to collect and preserve it. Defense attorneys review how evidence was collected, whether proper protocols were followed, how samples were packaged and stored, who handled the evidence and when, whether documentation is complete. Missouri law requires that evidence be obtained and handled lawfully. RSMO Section 650.055 sets rules for how DNA samples are collected, tracked, stored, and maintained within Missouri's DNA databank system. These laws are intended to prevent contamination, misidentification, and improper handling. Breaks in chain of custody, improper storage, or contamination can affect both reliability and admissibility. Process matters because errors can compromise results long before analysis even begins. Forensic medical exams and physical findings. Many sex crime cases involve sexual assault forensic exams, often called safe kits. These exams may document reported symptoms, observed injuries, biological samples, medical findings. Missouri law requires sexual assault forensic exams to follow specific rules. Under RSMO Section 595.220, exams must be conducted by trained medical professionals. Evidence must be properly collected and preserved, and the findings must be documented so they can later be used in court. Physical findings are frequently misunderstood. The absence of injury does not prove consent. The presence of injury does not automatically prove a crime. Defense attorneys evaluate whether medical findings actually support the legal elements of the charged offense. Probability, language, and misunderstanding. Matches. DNA results are often reported using probability language. Terms like match can be misleading. DNA evidence does not usually state that a person is the source with absolute certainty. Instead, it expresses statistical likelihoods. Jurors may misunderstand these probabilities, especially when they are presented without context. Defense attorneys evaluate whether statistical conclusions are being overstated or mischaracterized. How defense attorneys evaluate forensic evidence. Defense attorneys approach forensic evidence methodically. They ask, what exactly was tested? How and when was it collected? What assumptions were made during analysis? Are alternative explanations consistent with the findings? Does the evidence actually support the elements of the charge? Forensic evidence must be evaluated alongside testimony, timelines, digital records, and investigative procedures. Standing alone, it rarely tells the full story. Common misconceptions about DNA evidence. Several assumptions frequently arise in sex crime cases. DNA proves a crime occurred. DNA shows presence, not criminal conduct. DNA proves guilt. DNA must be connected to unlawful behavior under the statute charged. No DNA means the allegation is false. Many cases proceed without biological evidence. All DNA evidence is equally reliable. Reliability depends on collection, handling, and interpretation. How forensic evidence fits into a broader defense strategy. DNA and forensic evidence rarely stand alone. They interact with witness credibility, timelines and opportunity, digital communications, procedural and constitutional issues. In some cases, forensic evidence strengthens the prosecution's case. In others, it introduces uncertainty or undermines assumptions made early in the investigation. Defense strategy is shaped by how forensic evidence fits into the entire evidentiary picture, not by the mere presence of DNA. Chapter 8. Digital Evidence in Missouri Sex Crime Cases. Digital evidence plays a central role in many sex crime cases. Text messages, social media, photos, location data, and online accounts often become focal points early in an investigation. Because digital evidence feels objective and permanent, it is frequently misunderstood. Many people assume messages speak for themselves, or that deleted content implies wrongdoing. In reality, digital evidence often shows fragments of information that require interpretation and context. Like forensic evidence, digital evidence must be evaluated carefully, both in terms of what it shows and how it was obtained. Why digital evidence carries so much weight. Digital evidence often feels more reliable than witness testimony because it appears recorded, time-stamped, and factual. However, digital evidence rarely tells the full story. It reflects only what was captured, preserved, and later extracted, not everything that occurred. Common types of digital evidence. Digital evidence in Missouri sex crime cases may include text messages and messaging apps, social media posts, comments, and direct messages, photos and videos stored on devices or in cloud accounts, emails, call logs and contact records, location data from phones or apps. Each category comes with limitations. Some data is incomplete. Some is automatically deleted. Some require expert interpretation to be fully reliable. When messages are taken out of sequence. One of the most common issues with digital evidence is loss of context. Messages are often presented as screenshots, as isolated excerpts, without earlier or later conversations. Criminal defense attorneys examine whether messages were selected rather than complete, what conversations occurred before or after, whether tone, sarcasm, or inside references were lost, whether statements were made jokingly, emotionally, or reactively. A message rarely explains intent on its own. Meaning often changes when evaluated in the surrounding context. Deleted, missing, or incomplete digital evidence. Deleted or missing digital evidence is common and does not automatically imply wrongdoing. Digital gaps may exist because messages were deleted automatically. Apps have retention limits. Devices were replaced or reset. Cloud syncing failed. Content was never saved. Defense attorneys evaluate what data exists, what data is missing, whether missing data is ordinary or unusual, whether conclusions are being drawn from absence rather than proof. Device and account attribution issues. The state must prove who actually sent a message, accessed an account, or used a device. Defense attorneys examine whether devices were shared, whether passwords were known by others, whether accounts were logged in on multiple devices, whether impersonation or unauthorized access is possible, whether the accused can be reliably linked to the activity. In many cases, digital evidence shows activity, but not necessarily identity. Timing, metadata, and interpretation problems. Digital evidence often appears precise, but timing issues are common. Defense attorneys evaluate whether timestamps reflect device time or server time, whether time zones were applied correctly, whether content was edited, forwarded, or reposted, whether metadata is complete or partial. Like DNA evidence, digital evidence rarely comes with a reliable timestamp that conclusively ties it to a specific moment or event. Deleted, missing, or incomplete digital evidence. Deleted or missing digital evidence is common and does not automatically imply wrongdoing. Digital gaps may exist because messages were deleted automatically. Apps have retention limits. Devices were replaced or reset. Cloud syncing failed. Content was never saved. Defense attorneys evaluate what data exists, what data is missing, whether missing data is ordinary or unusual, whether conclusions are being drawn from absence rather than proof. Device and account attribution issues. The state must prove who actually sent a message, accessed an account, or used a device. Defense attorneys examine whether devices were shared, whether passwords were known by others, whether accounts were logged in on multiple devices, whether impersonation or unauthorized access is possible, whether the accused can be reliably linked to the activity. In many cases, digital evidence shows activity, but not necessarily identity. Timing, metadata, and interpretation problems. Digital evidence often appears precise, but timing issues are common. Defense attorneys evaluate whether timestamps reflect device time or server time, whether time zones were applied correctly, whether content was edited, forwarded, or reposted, whether metadata is complete or partial. Like DNA evidence, digital evidence rarely comes with a reliable timestamp that conclusively ties it to a specific moment or event. Collection and search of digital evidence. Missouri law. Digital evidence must be collected lawfully. Under Chapter 542 of the Missouri Revised Statutes, law enforcement generally must obtain a judge-approved search warrant before searching digital devices or accounts. The warrant must be based on probable cause. Identify what devices or accounts may be searched. Limit the types of data officers are authorized to examine. Law enforcement must remain within the scope of the warrant. Timing and scope of digital searches. Phones and devices are often seized early, but searched later. Under RSMO Section 542.271, search warrants must be executed properly and documented. Defense attorneys examine when devices were seized, when data was actually searched, whether searches occurred long after seizure, whether the search exceeded the warrant's scope. Delays and overbroad searches can raise questions about legality and reliability. Preservation, extraction, and handling of digital evidence. Digital evidence must be preserved and extracted correctly. Defense attorneys review whether original data was preserved, what extraction tools were used, whether the extraction was complete or selective, whether documentation is clear and consistent. Errors during extraction can result in missing data, altered timestamps, incomplete records. As with physical evidence, process matters. Expert interpretation of digital evidence. Digital evidence often requires expert explanation. Experts may interpret metadata, location data, app behavior, message logs. Missouri law governs expert testimony through Chapter 490 of the Missouri Revised Statutes. Experts must be properly qualified. Opinions must be based on accepted methods. Methods must be applied correctly to the data. Conclusions must not exceed what the evidence supports. Experts explain data without offering an opinion on guilt. Common misconceptions about digital evidence. Digital evidence is often misunderstood. Common assumptions include texts prove intent. Deleted messages show guilt. Screenshots are complete and reliable. Location data is exact. Digital evidence tells the whole story. Defense attorneys examine whether these assumptions are supported by the actual data. How digital evidence fits into a defense strategy. Digital evidence rarely stands alone. It must be evaluated alongside witness statements, forensic evidence, timelines, and opportunity. Statutory elements of the charge. How the evidence was collected. In some cases, digital evidence supports the accusation. In others, it introduces doubt, contradicts assumptions, or reveals missing context. Chapter 9. Constitutional and procedural defenses in Missouri sex crime cases. Any criminal case is largely shaped by the evidence available and how it is presented in court. In many cases, one of the most important defense issues is not just what evidence exists, but what evidence the law allows a jury to hear. While law enforcement and prosecutors have extensive powers and resources to help them build their cases, both Missouri law and the U.S. Constitution provide equally extensive protections to those accused. Constitutional and procedural defenses focus on how the government obtained evidence, how it handled the case, and whether the process stayed within legal limits. When rules are broken, the defense may be able to keep certain evidence out of court, limit how the prosecution can use it, expose reliability problems that weaken the state's evidence. Illegal searches and seizures. The Fourth Amendment of the U.S. Constitution protects against unreasonable searches and seizures. In Missouri, those protections show up most often through Chapter 542 of the Missouri Revised Statutes, which governs search warrants and how searches are conducted. Law enforcement does not have unlimited authority to collect evidence. In most situations, officers need a judge-approved warrant before searching private spaces or seizing property. What Missouri law requires for a search warrant. Under RSMO, Section 542.276, a warrant application must be in writing and must do more than express suspicion. That means officers must present specific facts to a judge, not just suspicion. The judge must decide those facts establish probable cause, meaning a reasonable basis to believe evidence of a crime will be found in the place to be searched. The warrant must clearly describe what can be searched. The warrant must clearly describe what can be seized. Officers must stay within those limits. These protections apply to homes and apartments, vehicles, phones and computers, cloud or account-based data, physical and biological evidence. A warrant is legal authority, but it is limited authority grounded in constitutional protections. Defense challenges to probable cause. A constitutional defense may include challenging whether the warrant should have been issued in the first place. That can include arguments that the warrant application relied on conclusions instead of facts, failed to connect the allegation to the place searched, used outdated, stale information, left out important details that would have changed the judge's evaluation. Missouri's statute is direct here. Section 542.276 states, "A warrant is deemed invalid if issued without probable cause." That matters because, if the warrant is invalid, the evidence taken under it may be challenged. Overbroad warrants and scope problems. Even when probable cause exists, a warrant still has limits. Under Section 542.276, a warrant must clearly spell out what officers are allowed to look for and take, where or from whom they are allowed to look. It must be specific enough that an officer can easily tell what is permitted and what is not. Defense challenges often focus on scope problems like, the warrant description was too vague. The categories were too broad for the allegation. Officers searched beyond what the warrant actually authorized. Important note: a successful challenge to the warrant won't necessarily mean that all evidence is thrown out, just the evidence collected that was beyond the scope of the warrant. Execution, timing, and documentation problems. Even a valid warrant can create procedural issues if it is executed improperly. Missouri's statute sets practical requirements that defense teams review closely. Time limits. A search warrant cannot sit unused indefinitely. Officers are expected to carry it out promptly. In most cases, if it is not executed and returned within 10 days, it expires. Return and inventory. After the search is completed, officers must report back to the judge who issued the warrant. They must explain how the search was carried out and provide a detailed list of what was taken. When a warrant can be invalid. Missouri law lists specific reasons a warrant can be considered invalid. For example, if it was not carried out within the required time, or if it failed to clearly describe what could be searched or seized, the warrant may not hold up. These are not abstract rules. They create concrete points of challenge when the timeline is unclear. The inventory doesn't match what was actually taken. Seized items can't be reliably tied to the search. Later searches of seized property drift away from the original probable cause basis. Consent, searches, and permission problems. Sometimes searches happen without a warrant because officers claim consent. Consent-based defenses are fact-specific, but the basic legal questions are consistent. Who gave consent? Did that person have authority over the place/device/account? Was consent voluntary, or was it pressured or implied? Did officers stay within the scope of what was actually permitted? Consent is not unlimited permission, and in shared homes and shared devices, authority and scope become key issues. Motions to suppress evidence in Missouri. When evidence is obtained unlawfully, Missouri provides a direct mechanism to challenge its use in court. Under RSMO Section 542.296, a person aggrieved by an unlawful seizure, a person whose property was unlawfully searched or taken, may file a motion to suppress the use in evidence of what was seized. If the defense attorney successfully argues that the seizure was unlawful, the judge may say that the evidence cannot be used. Even partial suppression can change a case dramatically, especially when the prosecution's theory depends on what was found. Constitutional challenges to statements and testimony. Not all procedural defenses involve physical evidence. Many sex crime cases turn on statements, especially early statements made before the accused understands what evidence exists. Statements may be from the accuser, the accused, or from witnesses corroborating the accuser's story. The Constitution places limits on how those statements are obtained and how they can be used in court. When those limits are crossed, the defense may challenge the reliability or admissibility of the testimony itself. Fifth Amendment: voluntariness and self-incrimination. The Fifth Amendment protects against compelled self-incrimination. In practical terms, this means statements made by the accused must be voluntary to be used in court. In custodial interrogations, this often includes compliance with what are commonly known as Miranda warnings. When someone is in custody and being questioned, officers must generally advise them of their right to remain silent and their right to an attorney. If required warnings are not properly given, statements made during that interrogation may be excluded. Note: this does not automatically invalidate every statement before or after. But the issue goes beyond whether warnings were read. Defense challenges frequently focus on whether the statement was truly voluntary under the circumstances. Common concerns include questioning that becomes accusatory or confrontational, situations where the person did not feel free to leave, implied promises, "This will go better if you explain it," pressure tied to family, employment, or reputation, repeated questioning designed to wear someone down, selective recording or summaries that omit important context. Even when someone intends to cooperate, stress, fear, or confusion can affect how statements are made and later interpreted. If a statement was obtained through coercion, pressure, or improper custodial questioning, the defense may ask the court to exclude it. Witness pressure and reliability concerns. Constitutional and procedural issues also arise when witnesses are pressured, influenced, or steered during an investigation. In sex crime cases, witness testimony often carries significant weight. That makes the manner in which it was obtained important. Defense review may focus on whether a witness was threatened with charges unless they cooperated. Promises of leniency or favorable treatment were tied to specific testimony. Questioning was leading or suggestive. Repeated interviews shaped or refined the narrative over time. Vulnerable witnesses were influenced by authority figures. When testimony is shaped by pressure rather than independent memory, reliability becomes a central issue. In some cases, these concerns are addressed through cross-examination. In others, They raise due process issues about fairness in the investigation itself. Sixth Amendment. Right to counsel. The Sixth Amendment guarantees the right to counsel once formal criminal proceedings have begun. At that stage, certain interactions between law enforcement and the accused require heightened safeguards. Procedural challenges may arise when questioning continues after the accused has requested an attorney. Questioning continues after charges are filed without counsel present. Access to counsel is restricted during a critical stage. Officers attempt to bypass counsel to obtain statements. Identification procedures occur without required legal protections. When the right to counsel is violated, statements or identification evidence obtained during that violation may be challenged. Constitutional challenges to statements and testimony do not depend on arguing about what happened. They focus on whether the process used to obtain that testimony was lawful and fair. Confrontation and trial fairness defenses. Sex crime cases frequently rely on testimony. That's where constitutional trial protections become defense tools. The Sixth Amendment right to confront witnesses becomes a real defense issue when the prosecution tries to use testimonial statements without bringing the speaker into court. Prior recorded statements as substitutes for live testimony. Limitations on meaningful cross-examination. Basically, if the prosecution wants a jury to hear damaging statements, the defense generally has the right to challenge the source and test reliability. This shows up through evidentiary objections and rulings on what testimony and statements are allowed at trial. Due process and discovery violations. Due process also includes fairness in how the prosecution discloses evidence and how the case is handled after charges are filed. In Missouri, a major practical tool is Missouri Supreme Court Rule 25.03, which requires the state, upon written request, to disclose broad categories of materials in the prosecutor's possession, including reports, statements, electronic communications/data, expert reports, and items the state intends to introduce at trial. Defense-driven discovery issues often involve missing parts of message threads, incomplete downloads or selective exports of digital data, late disclosure of key reports or recordings, expert reports that omit underlying data, summaries of interviews where recordings should exist. This is where process becomes a defense issue again. If the defense cannot see the full record, it cannot test context. If disclosure comes late, it can affect preparation and fairness. If evidence is incomplete, it can distort what the jury thinks happened. Lost or destroyed evidence. Another due process issue is preservation. Some evidence disappears because of deleted messages, overwritten surveillance footage, lost device images or incomplete extractions, missing interview recordings, missing lab notes, or underlying data. A defense strategy may focus on what is missing, why it is missing, and whether the absence undermines the reliability of what remains. In many cases, the defense is not trying to prove a negative. It is showing that the state's evidence is incomplete, and that incompleteness matters when the burden of proof is beyond a reasonable doubt. Charging and procedural errors. That change exposure. Some procedural defenses attack the structure of the case itself. Examples include charging under the wrong statute or wrong degree, combining unrelated allegations in a way that is unfair, procedural errors that affect how counts can be tried or separated. These issues can matter because they can reduce exposure, narrow what the jury hears at one time, force the prosecution to prove each allegation separately and cleanly. Even when they don't end a case, they can reshape how the case is litigated. What these defenses do to a case. Constitutional and procedural defenses are not typically the entirety of one's defense. They are a category of defenses that can keep evidence out, limit what the prosecution can rely on, expose weaknesses created by investigative shortcuts, change leverage in negotiation, narrow the issues for trial. Sometimes the impact is direct, evidence excluded. Sometimes it's indirect. The evidence remains, but its credibility is damaged because the process was sloppy, incomplete, or unfair. Either way, constitutional and procedural failures can turn a case that looks strong on paper into a case with real vulnerabilities. Chapter 10. What sex crimes defense looks like in action. By this point, you understand what sex crime charges look like in Missouri, how investigations unfold, and the most common defense strategies used to challenge accusations and evidence. The final step is understanding how those strategies actually translate into outcomes. Most sex crime cases do not resolve because someone delivers one perfect argument in court. They resolve based on what evidence exists, whether that evidence is admissible, whether the state can prove each legal element beyond a reasonable doubt, how risks change as the case develops. Defense strategy is not a checklist. It is a coordinated process of identifying weaknesses, protecting rights, and forcing the prosecution to prove what it charged. Below are the most common paths a Missouri sex crime case can take, and how the defense strategies covered in this book affect each outcome. Outcome. Path 1. No charges are filed. Not every sex crime allegation results in formal charges. In Missouri, investigations often begin quietly. Officers gather statements, request records, and pursue warrants before the accused even knows an allegation exists. In some cases, defense involvement occurs before charges are filed. This is why you should always speak to a sex crimes defense lawyer once you're accused, instead of waiting for charges to be filed. Prosecutors do not file charges simply because an allegation exists. They file when they believe there is enough evidence to establish probable cause and later prove guilt beyond a reasonable doubt. Pre-charge defense work often focuses on identifying what statute the state would likely charge and what it would need to prove, preserving communications or records that provide context, exposing inconsistencies or timeline problems early, correcting misunderstandings before they become formal allegations, preventing avoidable statements that create damaging narratives. If the evidence is weak, incomplete, or contradicted by the record, a prosecutor may decline to file, as the state might not be able to justify the charge under Missouri law. Outcome, Path 2. Charges are filed, then the case is dismissed or dropped. Sometimes charges are filed quickly, before the evidence is fully tested. Sex crime cases may be charged based on the accuser's testimony, even when significant disputes exist about consent, identity, timelines, or credibility. A case may later be dismissed when a key witness becomes unreliable or recants. Digital or forensic evidence does not support the accusation. The state cannot prove a required element of the offense. A constitutional violation leads to suppression of major evidence. The prosecution reassesses the case after the defense exposes weaknesses. Dismissed or dropped after suppression. If a suppression motion succeeds, the impact can be immediate. When key evidence is excluded, such as a device extraction, communications obtained through an overbroad warrant, statements taken improperly, evidence seized without lawful authority. The prosecution may lose what it needs to move forward. Not every suppression motion ends a case, but when suppressed evidence is central to proving the charge, dismissal becomes far more likely. Dismissed or dropped when elements cannot be proven. Other dismissals are simpler. The facts do not match the statute. For example, the defense may show what is being accused does not actually fit the legal definition of the crime charged. The timeline cannot be proven. Identity or attribution is uncertain. The state charged the wrong degree of offense. In sex crime cases, outcomes often turn on whether the state can prove specific legal elements, not on assumptions about what must have happened. Dismissed cases versus dropped cases. Both dismissed and dropped mean the state is not moving forward with the case. However, the reasons why are different, and the final outcome might be different. A dropped case means the prosecutor simply decided not to move forward with the case. This typically happens when new information comes to light, certain evidence is suppressed, or the accuser or a key witness recants their statement. The state can refile a dropped case later if new evidence emerges. A dismissed case means a judge issued a formal court order to end the case, typically after arguments and motions presented by both the state and defense at official hearings. If the judge dismisses a case without prejudice, that means the state may be allowed to refile the charges later. With prejudice means the case cannot be refiled. Dismissed or dropped cases can occur at any time during the criminal proceedings, even during trial. Outcome. Path 3. Charges are reduced. Charges in sex crime cases are sometimes filed at a high level early. This can happen when the facts are still uncertain. Prosecutors anticipate credibility battles. The state uses severe charges as leverage. Degrees of offenses are difficult for laypeople to distinguish. As the case develops, charges may be reduced if the evidence is weaker than the initial allegation suggested. Forensic findings do not support the charged degree. Digital records contradict key parts of the timeline. Inconsistencies create reasonable doubt about required elements. Constitutional issues limit what evidence can be used. A strong defense does not simply argue the accusation is false. It forces the prosecution to defend its charging decision against the elements of the statute and the limitations of its evidence. Charge reductions are often the result of forcing clarity on what the state can actually prove, narrowing the case to admissible evidence, exposing overreach early enough that the state must reassess. Reductions can significantly change sentencing exposure and case direction, even if the case does not disappear entirely. Outcome. Path 4. A plea agreement. Many Missouri sex crime cases resolve through negotiated outcomes. For the prosecution, there is always the possibility that a jury will find reasonable doubt. For the defense, there is the possibility of a conviction carrying the full sentencing exposure under the charged statute. The state may prefer a plea agreement when it secures a conviction without the uncertainty of a jury. Key witnesses may face difficult cross-examination. Evidentiary issues create risk at trial. Trial would require significant time and resources. A plea allows the prosecution to obtain a certain outcome rather than risk losing the case entirely. Defendants may consider a plea agreement when the admissible evidence appears strong. Trial carries significant sentencing exposure. The proposed resolution reduces the charge or degree. The agreement limits or avoids mandatory penalties. The certainty of a defined outcome outweighs the uncertainty of trial. A plea agreement is not an admission that the state's case is perfect. It is often a strategic decision made after evaluating risk, evidence, and potential consequences. The decision to accept or reject a plea depends on the specific facts, the strength of the defense, and the client's priorities. Outcome. Path 5. Trial and verdict. Only 2 to 3% of criminal cases go to trial. While rare, this typically happens when the defense believes the state cannot prove the charge beyond a reasonable doubt. The defense has strong factual or procedural challenges. Negotiations do not produce an acceptable outcome. The case turns on credibility disputes that must be tested in court. A trial is not one argument. It is the coordinated use of every defense concept covered in this book. The burden never shifts. At trial, the prosecution must prove every element of the charged offense beyond a reasonable doubt. The defense does not have to prove innocence. Defense strategy focuses on attacking the state's proof, exposing gaps and missing context, challenging reliability of witnesses and records, limiting evidence through objections or motions, presenting alternative explanations consistent with the evidence. How your defense tools show up at trial. Consent defense. A consent defense may rely on communications showing mutual participation, context that undermines force claims, credibility analysis showing inconsistencies, false allegation defense. A false allegation defense may focus on motive, contradictions across statements, external pressure or influence, DNA and forensic defense. DNA and forensic defense may focus on transfer possibilities, mixed samples, timing gaps, overstatement by experts. Digital evidence defense. Digital evidence defense may focus on attribution, who actually used the device, incomplete context, partial threads, missing messages, misleading excerpts and selective screenshots. Constitutional and procedural defense. Constitutional and procedural defense may shape what the jury hears at all, through suppression motions or rulings that limit evidence. Many trials are won and lost on what the jury never hears. Final takeaway. Sex crime allegations are serious, but a charge is not proof. Missouri law requires the state to prove each element beyond a reasonable doubt, using admissible evidence obtained through lawful procedures. Defense strategy is how that standard is enforced. A strong defense identifies what the state must prove, tests credibility and context, challenges weak or misleading evidence, exposes procedural violations, forces the prosecution to rely on proof, not assumptions, but outcomes are shaped by strategy and by whether the defense is built early, layered correctly, and grounded in what Missouri law actually requires. Chapter 11. Real results from sex crimes cases in Missouri. The following are real Missouri sex crime case results handled by Combs Waterkotte. Each case required strategic analysis of the law, the evidence, and the prosecution's burden of proof. Child endangerment, first degree. Result: charge reduced to misdemeanor child endangerment with SIS probation, and no conviction upon successful completion. Defense strategy: early intervention at the bond stage and aggressive negotiation with the prosecutor led to a charge reduction and probation-only outcome, avoiding a felony conviction. Child molestation and sodomy. Result: not guilty. Defense strategy: thorough cross-examination of the accuser, exposing issues in the testimony, led the jury to reject the prosecution's case. Child pornography. Result: dismissal. Defense strategy. Utilizing forensic analysis and expert testimony challenges was critical. By questioning the digital evidence and its interpretation, the firm secured dismissal before the case progressed. Forcible rape. Result: not guilty. Defense strategy. Being retained immediately after charges were filed allowed the team to build defense from day one, including investigation, evidence review, and preparation for trial, ultimately resulting in a not guilty verdict. Harassment and sexual misconduct. Result: sexual misconduct dismissed. Client resolved on harassment with a negotiated outcome. Defense strategy. Separating charges and negotiating effectively helped eliminate the most serious allegation while containing consequences on the lesser offense. Indecent exposure. Result: no felony conviction. Client received probation and avoided sex offender registration. Defense strategy. Focus on mitigating long-term fallout, felony status and registration exposure, through plea negotiations and framing the conduct in context. Sexual misconduct. Exposure allegation. Result: not guilty. Defense strategy. Jury trial approach that disputes identification and credibility issues, forcing the state to meet its burden beyond a reasonable doubt. Sodomy and child molestation. Juvenile. Result: probation through pretrial resolution after strategic investigation. Defense strategy. Thorough pretrial fact development and leveraging deposition results provided bargaining power that protected the young client from harsher penalties. Sodomy and incest. Juvenile. Result: probation. Defense strategy. Early action and advocacy led to a negotiated sentence tailored to the client's situation and minimized severe consequences. Statutory sodomy. Result: case dismissed at preliminary hearing due to lack of probable cause. Defense strategy. Persistent preliminary hearing challenge to the state's case, focusing on inconsistencies, resulted in a judge not finding probable cause, ending the case before trial. Statutory sodomy and incest. Juvenile. Result: not guilty after trial. Defense strategy. The team confronted serious multi-count allegations with trial readiness and detailed challenge to the state's statements and proof. What these results show. These outcomes demonstrate that effective sex crimes defense rests on several key approaches. Immediate legal involvement before evidence solidifies. Fact investigation and discovery leverage, often before formal charges. Cross-examination and credibility testing where testimony is central. Technical challenges to evidence, especially digital/forensic material. Strategic negotiation that narrows or reduces charges to protect futures. No two cases are alike, but these outcomes reflect a consistent focus on protecting clients' freedom, record, and future through tactical defense work and advocacy at every stage of the case. Expert sex crimes defense in Missouri. If you or a loved one has been accused of a sex crime in Missouri, help is only a phone call away. With over 60 years of combined criminal defense experience, Combs Waterkotte's Missouri criminal defense lawyers have successfully handled over 10,000 cases, many just like yours. Give us a call at 314-900-HELP or contact us online to start protecting your freedom and future today.